Welcome to the webinar. My name is Amit Rana. I'm a partner here in San Francisco. Today's webinar is the Hidden Edge Trade Secret Strategies for the AI Age. We're really excited that you're able to join us today. This is a topic that's been on a lot of people's minds lately as we talk to clients. AI is front of mind for so many people, and we're seeing a lot of evolving legal issues and policy debates around how trade secrets intersect with the AI world that we're living in now. So we're really excited to present on this topic today. Um, I will let my colleague Rebecca introduce herself. And Rebecca, I think you're muted.
That's a good start. My name is Rebecca Horton. I am a partner out of Venable's San Francisco office, in addition to practicing trade secrets litigation, which is obviously the subject matter of today's presentation. I also practice in a cross-section of IP, so also handle matters like trademark and copyright.
And like I said, my name is Amit. I'm a partner here in San Francisco. I co-chair our California commercial litigation practice. I routinely handle a lot of trade secret litigation and similar kind of competitor suits for clients in a lot of different industries. I've personally been really intrigued by the wave of AI and how it's being deployed by businesses. I think the attendees today are a testament to how AI is so it's being deployed in virtually every industry. I mean, we have, I think, 250 attendees today, from insurance companies to food and beverage clients to data brokers to traditional tech companies. Everybody, it seems, is looking for that additional edge from AI. I've really enjoyed thinking about how this technology is going to change our daily lives, whether it's professionally or personally. So I'm really excited to be here today to share my thoughts on how companies should think about trade secret strategies in this new AI world.
All right, with that, we'll just go over briefly what we're going to be covering today. First, we're going to just talk about generally why you're hearing discussion about the dilemma when it comes to the appropriate type of IP protection for AI. And then we're going to go on to talk about why trade secret law is being seen as a natural fit for AI-related innovation. We'll then go on to discuss what we're currently seeing in terms of disputes and risks as it relates to either the creation of AI tools, or so companies that are creating AI tools or companies that are using AI tools. We'll then cover practical strategies that companies can implement when they're looking to obtain that trade secret protection and sort of strengthen that trade secret protection for AI-related innovation. And lastly, we'll cover final takeaways. And we will try our best to, our goal is to provide some time at the end to answer questions. And if we have the opportunity, we'll answer questions in real time as well. And as it was mentioned, there's a chat box that you can use to submit your questions, and then we'll take it from there.
And one other thing to note is the webinar is certified for CLE credit. And so if you're in California, Colorado, Florida, Illinois, or New York, you can get CLE credit. So I will give you a top secret, perhaps not a trade secret, but a top secret code word about halfway through the presentation, and then again at the end, and you'll need that code word to get CLE credit.
All right, so why are you hearing a lot about there being a IP dilemma when it comes to AI related innovation? And a lot of it has to do with the characteristics of the different types of IP. So if you think about IP in sort of broad four buckets, we have patent, copyright, trade secret, and trademark. We're going to just table trademark for now. And a lot of it has to do with, in order to enforce your patents or your copyrights, you have to register it. And some of the requirements related to registration can sometimes cause companies pause as to whether or not that's the form of IP protection that they want to obtain for AI related innovation. So some of this has to do, for example, what is eligible subject matter. So for patents, for example, it needs to be something more than the use of AI in a new context, or the use of AI to automate an otherwise known process. So sometimes, right, then the AI related innovation might not be might not qualify to that patentable subject matter. Another aspect that can cause pause is the time it takes. So for patent applications, they can sometimes take upwards to 2 years, if not more, to obtain the registration. And then with copyrights, that it can be 3 to 9 months. And also just with the rate of innovation that's occurring with AI innovation, that as a result of it, right, waiting this amount of time to obtain protection for then what becomes essentially outdated innovation, then that can also cause pause. Another aspect is the disclosure requirement. So for patents, to obtain patent protection, when you're applying for a patent, you have to disclose what that invention is, right? And then with copyrights, there's a deposit requirement. So that will require you oftentimes to submit a copy of the work that you're seeking copyright protection for. And so that disclosure, sometimes companies are not interested in having to disclose what their AI innovation is. And the last, and probably another item that you have heard a lot about, is the authorship requirement. So the authorship, or the human aspect of it, right? So with patents, it requires there to be a human inventor. So a human inventor made a significant contribution to the invention. And with copyright, it requires there could be works. It requires a human author. So there can be works where AI might have assisted in the creation of the work, but if it's generated entirely by AI, that's not going to be subject to copyright protection. So as a result, going through some of those aspects of the registration in order to obtain the patent or the copyright registration to then be able to enforce those forms of IP, companies sometimes are not either interested, or the IP that they're looking to protect is not eligible. And that's why then trade secret has started to take center stage in terms of the form of IP protection available for AI-related innovation.
So let's take a very brief step back and just think conceptually about what a trade secret is. It's fundamentally a pretty simple concept. A trade secret is any information that derives independent economic value from not being generally known or readily ascertainable, and is subject to reasonable efforts to maintain its secrecy. And so it really breaks down into two prongs. There's some value through secrecy, and you've taken some reasonable measures to protect that. And we'll talk a lot today about why trade secrets are so well suited for the AI world. And one of them is the idea of what can be a trade secret is so broad. It really encompasses any form of information. People often think of a trade secret as the secret source code that generates your algorithm, or the top secret Coke recipe locked away in a safe in Atlanta is the example people think of. Those are good examples, but we'll talk today about the idea what information is protectable as a trade secret is intentionally broad, and it is intentionally very flexible, and that overlays into an AI world really well. And so in broad strokes, if it's a secret, if it's valuable and it's protected, it can probably qualify as a trade secret. And in some ways, you can kind of conceptualize this as the opposite of a patent. A patent is you're putting your concept into the world, you're showing it to the world, you're publishing it and saying, this is mine, I want protection of it. A trade secret is the exact opposite of that. You are going to guard the secrecy of that information, and it gains value because it is secret. The second prong of trade secret law is so the first prong is, what constitutes a trade secret? Again, very broad, very flexible. The second prong is what constitutes the misappropriation of a trade secret? And the law has really kind of divided into three categories here. The first is acquisition by improper means. And this is the most common and direct theory of trade secret misappropriation. And it occurs through your traditional concepts of deception or theft or violation of some duty. We'll talk a lot today about what improper means actually means, and we'll learn that it is ill-defined on purpose. The two kind of statutory regimes that govern trade secrets, the Federal Defend Trade Secrets Act and the Uniform Trade Secrets Act that has been codified by 49 states across the country, they both don't define improper means very clearly, and that's on purpose because it is intended to be kind of a living doctrine that is flexible and changes over time. The second way that trade secrets can be misappropriated is through use or disclosure without consent. And essentially that means you've acquired it through lawful means, but you're using it or disclosing it outside of those lawful means. And the most common example of this is you have some information that you've obtained through an NDA or a confidentiality agreement, but you're disclosing that outside the bounds of that NDA or confidentiality agreement. That is still misappropriation. And then the third that comes up less common is a third-party use or derivative misappropriation. And essentially, this is a downstream acquirer of some information if you knew or had reason to know that the information was improperly acquired. And so we'll talk about a lot of these concepts throughout the day today, but the most important one we want to focus on is what does it mean to acquire information through improper means, and how does that fit in with the world of AI, where AI systems are designed intentionally to share information. And so where is the line for what is it proper versus improper?
All right, so then in summary, this chart touches upon some of the topics that Amit and I just covered as it relates to the various types of IP protection that have been considered for AI-related innovation. And we don't have to go through each one, but as you can see, as you sort of move down each row, right, that sort of leads you naturally down to the bottom as to the nature and the strength of the fit of that type of IP for AI. And as you can see, right, when you sort of compare some of these aspects, characteristics, and do a side-by-side comparison, then ultimately people and companies are reaching the result that AI is a strong fit, or trade secret is a strong fit for AI-related innovation.
And really, I think that the 2 points here that are most important, or that jump out to me most, that makes trade secrets the natural fit for the AI world is there's no public disclosure requirement as there are in some of the traditional IP regimes. And so you necessarily can keep your secret secret, and you do not need to publish or put it out into the world as you would to get patent or copyright protections. And then the second piece of this is human involvement. As we have more and more AI generated content or AI generated outputs, trade secret protections can fill a gap where humans are not involved in that generation at all. And so let's talk a little bit about why, in contrast to why patent and copyright are not good fits, let's talk about why trade secrets are a good fit. The first, as we talked about earlier, the phrase I've heard, and I actually really like, is that trade secrets is a living doctrine. It's constantly evolving with technology and the world we live in. It's designed that way. As I mentioned earlier, the two statutes that kind of govern trade secrets are written in ways that allow it to adapt to evolving technologies. And so you think about the traditional forms of information that have been protected by trade secrets, designs or prototypes or financial information and records. We've seen as we move into more of a digital world over the last several decades, trade secret law has adapted to show that customer list and supplier list, when stored in a secret way and compiled through some economic investment, can also constitute trade secrets. You can compare that to 40 years ago, where you can just open the white pages and see everybody that lives in town that's a potential customer. But as we develop technologies to compile customer lists and make some economic investments into compiling those lists, that can be a trade secret. Marketing strategies, business models. Now we're starting to see more and more courts recognizing negative know-how. And so if you know something is not going to work, if you have that well documented and it is being kept secret, negative know-how can be a trade secret as well. There's a famous line that I really like from Judge Alsup here in San Francisco in the famous Waymo versus Uber trade secret case, where he said, well, does every departing employee need to get a frontal lobotomy to forget about everything they learned at their old firm? Well, no, but if you're able to demonstrate that there are reasonable efforts you're taking to keep information secret, and there is some independent economic value of that, that is afforded trade secret protections, and it is going to cover almost every form of information, including negative know-how. We talk a lot about software algorithms today and source code, even research data or software designs can be trade secrets.
But I think on that too, something that's really interesting and we're seeing now, especially with this sort of the next wave of a new technology is that, as Amit said, that negative know-how, right? How valuable that can be in terms of what is successful in getting you into the marketplace and being competitive in the market and leading the market and what has not been successful. And I think particularly in that sort of new and novel space, that negative know-how and being able to define that can certainly be an aspect of important trade secret protection that we'll talk about in a bit.
The second prong of the trade secret law that I think is really well suited for the AI world is what constitutes misappropriation. And we were talking about earlier, what does improper means actually mean? And so there's a couple of cases that I wanted to highlight that bookend kind of the doctrine of trade secret law. So way back in the 1970s, well before decades before the Defend Trade Secrets Act and well before even the Uniform Trade Secret Act was written by the law on uniform laws or the Commission on Uniform Laws, courts were always grappling with what information can be a trade secret and what constitutes improper means. Back in the 70s, DuPont developed what was unpatented, but what they considered to be a proprietary method to manufacture methanol. And they were building a massive factory in Texas to manufacture this proprietary system of methanol. One of its competitors had this bright idea that we'll just fly an airplane over the factory and take pictures of the manufacturing plant while it's under construction, and we'll understand exactly what the manufacturing process was. DuPont said, well, that's a misappropriation of our trade secrets because the photographs will reveal exactly what our proprietary manufacturing process looks like. The defendant said, well, I'm not doing anything wrong. I'm just flying in public airspace. I'm not violating any FAA regulations. I have no confidential relationship with DuPont. Where are the improper means here? Well, the court agreed with, this is out of the Fifth Circuit, and the court agreed with DuPont and said that it was improper for the defendants to take aerial photographs over the manufacturing plant. And the court gave us our first real doctrinal understanding of improper means. And what it did was it balanced the precautions that DuPont should have been taking to protect its secrets and said, well, we have to think through what would be reasonable or unreasonable for DuPont to do here. And okay, they could have put a temporary roof over their manufacturing facility while it was under construction, but that seems like an unreasonable precaution. And reasonable precautions against predatory eyes. So the quote from the case was reasonable precautions against predatory eyes we may require, but an impenetrable fortress is an unreasonable requirement. And it, like I said, it gave us our first doctrinal understanding of improper means. And the quote that the Fifth Circuit gave us in the DuPont versus Christopher case was improper means will always be a term of many nuances determined by the time, place, and circumstances. And so maybe 50 years before this case, flying an airplane over a factory wasn't even an option to take aerial photographs. But as the world evolved, the doctrine of trade secret law and improper means also evolved. Let's fast forward 50 years to just last year, where the court adopted this improper means test in the present day. There's a company, CompuLife, that developed a proprietary software system to generate life insurance quotes using confidential encrypted database of insurance rate data. It was basically an algorithm that worked as an actuarial for insurance quotes. Defendants had a really sophisticated scraping software that was able to go into CompuWare's system. It mimicked the software's input-output structures and allowed them to simulate legitimate quote generation, but it did this millions of times and was able to extract all the data that formed the basis of CompuWare's algorithms. The court in that case also held that this conduct qualified as a trade secret misappropriation, even though the individual quotes were publicly accessible, because the volume and method of access through the scraping AI technology was intended to circumvent the limitations put into place. And it reaffirmed this concept that improper means is always going to be a flexible standard based on the time, place, and circumstances of the technology being used and what measures the property holder is using to safeguard that information. It also reaffirmed that improper means does not need to be independently illegal. In this case, the scraping technology that was being used was not illegal. It was accessing publicly available information. It was just doing it millions of times through an AI software. But the court actually likened it back to the DuPont case and said, reverse engineering code is kind of similar to aerial industrial espionage, and it's a modern analog to surveillance that circumvents reasonable security measures that CompuLife had put into place. And then it actually quoted back to the DuPont Christopher case and said that it's always going to be determined by the time, place, and circumstances of how the technology is being used, and we'll always have to determine what improper means based on the technology and the time, place, and circumstances.
And I think in those two cases too, it's interesting how the court looks at, sort of creates a distinction or draws there's a dichotomy between the capabilities of a human individually, right, to like view in terms of what DuPont was doing, or in order to view and use the publicly available insurance quotes, versus what the capabilities are then when you involve technology, right? And then how that uh, sort of massively expands the capabilities and the ability to sort of view what these sort of proprietary technologies are. And we see, and that discussion is undergoing currently today, even in the current decisions that come down from two Northern District of California decisions that come down in copyright infringement cases as it relates to AI tools, is this real evaluation regarding the sort of capabilities of AI tools and how those are beyond those that have ever been possible by individual, humans or a team of individuals at any given company.
Yeah, and back to the theme, precisely why we're seeing so many people apply trade secret protections to AI technologies, because these doctrines do kind of distinguish between, as Rebecca pointed out, human involvement in gathering data versus uh, technology's application to potentially misappropriating data. And it's kind of uniquely suited to kind of identify how that technology is evolving over time.
All right, so then why is trade secrets' historic ability to evolve to new technology particularly relevant to AI? And this is in light of the extensive capabilities and uses we're currently seeing and anticipate in the near future. So on the left, we have some of the technological capabilities that that are currently available in AI tools. Things like natural language processing, machine learning, so computers able to respond to the spoken word or written text from a human, or ability to learn autonomously from data and algorithms. We have the capability, of vision. So if we think about things like self-driving cars, and then everything to things like evolutionary computation. So that's the use of algorithms to simulate biological evolution, and the ability to use AI tools to sort of expedite that ability to do that computation, and then in turn have major sort of implications in the medical community. And then in turn, on the right, you see, and this is certainly not exhaustive, but you see the ways that these AI tools are then being used, be it predictive analysis, fraud detection in the medical field, marketing and promotion, risk management and analysis. So take, one example, for example, models that are doing natural language processing, that ability to sort of interact and communicate with humans. We're seeing that with virtual assistants, right? And then that sort of technology is being implemented in areas like customer service. We can go on to the next slide. And then in light of that extensive capability of technological capabilities of AI, and then the use, this is leading us to why the IP related to this AI is so hugely valuable, right? It's at the very least, it helps companies gain and maintain a competitive edge. And that as a result, there's a very real interest in protecting that IP. But how do we what is the IP that we're seeking to protect? And then obviously, how do we shore up that trade secret protection? And there are components of AI that companies are currently looking at to protect under the umbrella of trade secret law. This is anything from the data, so the proprietary training sets, the architecture, so model design, parameters, the training process, so techniques, tunings, prompts, outputs. So this could be fine-tuned responses. It could be summaries that are outputted from AI tools, marketing and business strategies, financial modeling and prediction, to the hardware, so chips and the deployment environment. And then something to go to that. So, right, these are sort of some of the components of AI that have worked for companies and that they're interested in protecting because it's proven to be valuable to their business. There's also the negative know-how associated with these things. So what has not worked, right? So if it's sort of the outputs regarding marketing and business strategies, what strategies were not successful that were tried and not successful? And there's value in that, right? And not sort of pursuing that strategy that didn't prove to benefit the company in the way that was anticipated. And I think here you can look, and as we sort of cover this, this sort of has some kind of brings us back to that earlier slide that Amit went through that had a bunch of bullet points regarding different info that courts have to date found to be trade secret protectable or to be eligible for trade secret protection, subject to parties being able to satisfy that pleading and burden of proof requirement. But these areas, right, are somewhat, but there's sort of that application of that sort of broad category of eligible trade information eligible for trade secret protection it's at its nascent stage in the sense of how that and the best way to ensure that you get trade secret protection as it relates to its application to AI.
Yeah,
And
and as
go ahead, Nomit.
I was gonna say, as the participants well know, AI is just it's permeating every part of the business world, and that's why I think, back to our original theme, it's so well suited to this because it's not limited to any particular format or field of information. As long as back to our original, elements of trade secret law, as long as the information can derive economic value from not being generally known, and you take reasonable steps to keep it secret, it probably will qualify for trade secret protections. And so you can see it from data, architecture, processes, outputs, hardware. Every component of how AI is integrating into your business has some implication for trade secret protections.
And then also just on this slide too, perhaps a bit on the nose, right? But there's this sort of constant discussion regarding the black box issue of AI, right? Is that inherently there's this aspect to AI where it's difficult to explain the internal workings of the algorithm that's underlying, for example, the AI tool, which then makes sort of trade secret protection for that algorithm more difficult because of the inability to sort of define what the algorithm is or what it does. But the components are more readily defined, and the ability to define them then takes you sort of closer to that trade secret protection that would be available as long as there's sort of value associated with, as long as they're maintained a secret, and then there's the value associated with the secrecy of that information.
The other fascinating aspect of how we're seeing trade secret protections play out in the AI world is it is novel. These are issues of first impression for every court that's seeing it. These are edge cases that we're just starting to see trickle through the courts right now. We don't even have decisions on a lot of these complaints and lawsuits that are being filed on seeking trade secret protections for the AI technologies that are at issue. But let's walk through a few examples of how this is playing out in active litigation. Um, you know, in a traditional context, when we think about trade secret protections, we often think about or when we think about trade secret misappropriation, we often think about reaching some physical barrier or a digital security. It's the traditional case of the departing employee sticks his USB thumb drive into the computer and downloads a bunch of data, or it's uploading his documents to the cloud. But in the AI era, it's a lot more complicated and nuanced. Attackers could potentially use the language models, or they could exploit the language models to reveal its own internal workings. What we're seeing is they call them prompt injection attacks, and it's by prompting malicious instructions to instruct the language model to override its own safeguards and potentially reveal its internal logic or its system prompts, which is really the blueprint of how the AI systems work. And so that behavioral blueprint for the AI system is oftentimes highly refined. It's the result of a lot of economic investment, iteration, domain-specific fine-tuning. Obviously, that the code and the system prompts that power the AI system, the language models, is very proprietary for a lot of businesses. And so many companies are arguing in court that these kinds of system prompts or model instructions or behavior generating code, they're protectable trade secrets, and that if you're using prompt injection attacks, hacking attacks through prompts, that can constitute improper means. And the most recent example of this was the most interesting example I've seen of this is the Open Evidence versus Pathway Medical case that's pending in Massachusetts right now. Open Evidence is it's a technology that uses AI powered medical information to help doctors identify medication interactions and to provide diagnostic support for physicians. A competitor was able to impersonate a healthcare provider. He went into the AI system and launched dozens of prompt injection attacks to try to trick the AI into revealing its core instructions, its systems prompt, basically. It worked. The prompt essentially, the brain behind how the AI reasons and responds was revealed through this prompt injection. But it raises a lot of questions, right? I mean, if you can go into an AI system and just talk to it through prompts and trick it into revealing the prompt code behind the language model, isn't it readily ascertainable, or did you really take reasonable measures to maintain that secrecy of that information? The litigation is still playing out right now. The complaint was just filed a couple of months ago. The defendants are making that precise argument that, if somebody can just log into a AI chat and use prompts to get the AI to reveal its proprietary code, then you probably haven't maintained the secrecy of that code, or is really readily ascertainable and it doesn't constitute a trade secret. I think it kind of underscores two key points we've been talking about today. First is that AI-related trade secrets aren't just about source code anymore. They extend to prompt design, training data pipelines, model behavior, even safeguards that are used to keep a lot of that data secure can be afforded trade secret protections. And second, the methods of misappropriation are evolving. We're seeing attacks that exploit the very mechanics of these AI systems, the large language models, that raise questions for courts about what qualifies as improper means under both the federal law and the state laws. As we've seen, it's going to play out in the courts, and we don't really know exactly how the courts are going to land on this, but it's raising a lot of interesting questions about how trade secret doctrines are intersecting with the way we're using AI models. The models that are uh, by design intended to share information and intended to be iterative with the users. Um, so the second really interesting aspect of trade secret law that we're seeing play out in litigation right now is how are AI business tools being used in a way that can still safeguard a business's confidential information? And most interesting example of this was the West Technology Group versus Sunstrom case. Um, you know, Almost every company is deploying some AI tools to help it with all facets of their business, whether it's an AI assistant or an AI note taker or an AI proofreader. If you're feeding into those systems confidential or proprietary information, are you losing trade secret protections by virtue of it being fed into the language models? And in the West Technology Group, there was a sales employee that was surreptitiously using an AI note application in his internal meetings. That application was transcribing those meetings, summarizing those meetings, and automatically transmitting those notes to the employee's account. The employee's account was actually keyed or linked to his personal email address. The problem here is these meetings were talking about confidential trade secret information. So all that information is being synthesized and pushed externally to this employee's external personal email account. He was obviously terminated, and they filed suit against the employee for trade secret misappropriation. The use of AI here wasn't, some model training or generation, but in the unauthorized data captured by that AI system, and then the disclosure of that information to the user's account, which is external to the business enterprise software. Um, the company did end up getting a preliminary injunction and the case settled. And so we don't know exactly how the courts are going to think about these concepts. But again, it ties into some of the broader themes we're talking about today, that trade secret law is flexible enough to address all these emerging AI risk. But companies, it's still incumbent upon the companies to anticipate these back end model leaks. Um, and not just the model leaks, but also human behavior and unsanctioned tools and inadvertent disclosures, and how people are actually utilizing these tools in their everyday business, in their everyday jobs at the business. And we're going to see that play out. This was a clear example of, you know, external disclosure, which will destroy trade secret protection. It's also a good example of, perhaps a court will find that you weren't taking reasonable measures to protect the secrecy of this information if you don't have some internal safeguards in place to make sure that employees aren't using third-party or unauthorized AI tools to take that information and feed it into its language models. So again, I think the takeaway is that the companies must be anticipating these things, and you need to put in safeguards into place to make sure that these unsanctioned tools or the human behavior isn't circumventing some of the, say, trade secret protections you have already in place for your confidential information.
All right, and we're about halfway through. So that secret code we promised to provide you is all caps trade 2025. And we'll be providing it again towards the end of the presentation. All right, so Amit talked about some of the recent cases that we're seeing, and once again, sort of both addressing the companies that are developing AI tools and trade secret issues and disputes that are arising from that, and then the use of AI tools in sort of the everyday business, right? And the implications that can have on your trade secret protection or in the trade secrets that you're seeking to protect. It's also, we're seeing recent cases as it relates to employee mobility. Now, employee mobility has been a fact pattern in trade secret misappropriation cases for a long time. So that's not new or novel to AI. But in light of what we can talk about a little bit, what we're seeing in the AI space, it promises to be a big area of trade secret misappropriation cases going forward. So we have the neural magic case. So that was in Massachusetts, and that was a few years ago. It was back in 2020. But there was an allegation that a former employee took an algorithm related to machine learning and took it to its new employer. And then subsequently, then the former employee brought suit. That case settled. But that's just sort of the beginning, right? The tip of the iceberg of these sort of more traditional trade secret scenarios that you're now seeing applied to AI. And we're seeing as most recently in a couple months ago in June, or a month ago in June, in the Northern District of California, in the case, in the Tesla case, where um, the complaint alleges that a former employee misappropriated trade secrets related to the autonomous humanoid robotic project to then create and then departed and then created a competing robotic startup. And and the allegations state that that company was able to sort of get off the ground within in an incredibly quick time, within 7 months or so, and was claiming that they also were about to release the ability sort of and functionality of robotic hands. And so that obviously is at its very early stages, and this is just the tip of the iceberg in the sense of movement between AI companies, and then the risk that can pose to then the trade secrets that are forming the platform or that are at the foundation of companies, either because of the tools they're using or because of the tools that they're creating. And we will just see this expansion mobility increase, because I mean, it depends on what statistic you look at, but some are saying that there's over 90,000 AI companies across the world as of today, and that in the US alone, AI startups have raised in excess of 100 billion in just the first 6 months of 2025, which is more than the entirety of 2024. So obviously this space is expanding rapidly, and then new companies are coming into into the space, and also maybe in the particular space that companies are in, and then in turn the companies are growing, and then, as you can imagine, employees might look to then change companies, and then that sort of puts a focus on then the trade secrets that are being protected and differentiating one company from another. Another issue that we're seeing is regarding the discoverability of trade secrets entered into AI systems. And we're seeing this most recently in a case in the Northern District of California. It was ordered that the chat logs, user chat logs, be preserved due to the potential relevance to the claims at issue in that case. And this was regardless of whether the users indicated in their preferences that they wanted their chat logs saved. Now, it excluded from that order preservation of the chat logs associated with the enterprise models. But this causes then a bigger discussion about the fact that although we know it's now we're seeing it in practice that user logs are not confidential. There is no privacy associated with the user chat logs. There's no attorney-client privilege formed in the course of using these chat logs, and there's no confidentiality there, right? And so we see scenarios where, from incredibly private information being put into these user chats, something from that on that end of the spectrum to then trade secrets being put into the chats. And there are some situations that have currently arose where employees are entering proprietary information like source code to generate, verify, and optimize. And sometimes that's not being entered into an enterprise model that's sort of closed and specific to the company. It's being entered into more generally available models without the sort of confidentiality safeguards in place that sort of form the basis of trade secret protection. And you can see scenarios where I know that there's this sort of more open discussion that, outputs might not disclose what a trade secret is because the output won't, an output might not be identical to what the input was. So if it was trained on trade secrets, the output might not be, identical to that trade secret. But in light of this sort of issue that we're seeing regarding the discoverability of user chat logs, or, if there was sort of a cybersecurity breach, for example, and those things became public, that input then, as it is, then becomes public or could become public. And that then, causes some serious concern regarding the information that's being, inputted into these models. Go to the next slide. And then it's always important to just talk about more generally some of the litigation trends we see as it relates to trade secrets. So, and why litigation might actually be pursued, and one of the things that you see is there's been a number of cases with exceptionally high damages awards. Most recently, we saw that one for about $2 billion. It's on appeal currently. We've seen other awards for $800 million or $700 million. Those two awards were subsequently reduced on appeal and sort of cut in half, but that's still an immensely sizable award. And as a result, a lot of risk associated if you're sort of depending on which side of the V you're on when it comes to trade secret litigation. Another aspect of trade secret litigation that's actually unique to trade secrets is the extraterritorial reach. So that's, in this context, we're talking about, the reach of the law beyond the US border. And there's a recent decision in 2024 out of the Seventh Circuit that said the Defend Trade Secret Act applied to extraterritorial conduct and sales. And that analysis looked at, and with other areas of IP, there's more of a cutoff at the border in terms of the availability to obtain sales relating to the infringement conduct that happened, for example, abroad. But with trade secrets, what the Seventh Circuit came down and affirmed is that if there is an act in furtherance of the misappropriation that happened in the US, then the company is entitled to any sales associated to the misappropriation that occurred abroad. And in this case, the act in furtherance that happened in the US was advertising, marketing, and promotion of the products that embodied the stolen trade secrets. And there was an argument made, but the courts rejected it, that it required the completion of the misappropriating act to happen in the US to it be able to then entitle the plaintiff to obtain then the sales that happened abroad. The court didn't require such a stringent standard, and it was just the marketing and promotion of the product in the US that was sufficient then to create that connection and entitlement to foreign sales. Another aspect that was that was sort of decided in that case and more unique on the trade secret side is it's not as strong of a causal nexus between the domestic acts and the foreign sales. In other cases, a lot of times the other types of IP, a lot of times the analysis is whether or not the domestic acts, so whatever happened in the US caused the foreign sales and that direct causal nexus. Whereas in the trade secret misappropriation case, in this case particularly, that causal nexus was not required. It was just acts in furtherance. And then we would be remiss, and then there's some other aspects too. A lot of times in trade secret claims, we see trade secret misappropriation cases, we see other types of IP or other types of claims asserted as well. There is the distinction in trade secret misappropriation cases where there is the required showing of actual harm. And we'd be remiss if we don't talk about the other forms. So right now we've been talking about a lot of these cases in the context of federal district courts or in the courts themselves, but there's another forum where trade secret claims can be brought and considered, and that's the ITC. And this venue has been increasingly used. It obviously has certain parameters and requirements associated with it. It deals with the importation of products into the US. So the products being imported would then be the products alleged to have the misappropriated trade secrets. But that process sometimes can be advantageous to parties if they're looking for a quicker resolution and if they're just looking to sort of have to stop that importation and ideally obtain an exclusion order that prevents the importation of those products embodying the misappropriated trade secrets.
So we've talked a lot today about the value and the versatility of trade secret protections for AI systems, but it also creates some tensions. And from a normative perspective, there are legitimate policy and legal questions about how much trade secret protection is warranted for some of these systems. And we're running a little bit short of time, so I'll go quickly through some of this. But it does limit innovation and collaboration, right? I mean, if key model components and training data and language models and the architecture are all locked behind trade secrets, it stifles open research and interoperability of AI systems across the industry. And I think it's particularly apt for the AI world because collaboration has been the driver of progress in the industry, and many models are actually open sourced. And are we going to stifle all of that by virtue of trade secret protections and the law taking too draconian of a view on how trade secrets would apply to these systems? The other thing is there is the potential for like rent seeking or monopolization over some data. This comes up a lot for our data clients who are aggregating data using AI scraping tools. But they're collecting publicly available data. I mean, isn't that the point of the internet, that everybody should have equal access to the publicly available data? And should all the data that you collect, even if it is through an AI scraping tool, be subject to trade secret protections? And we're going to see that play out in the courts, but where we land from a policy perspective or from a legal perspective on that has implications for everybody in the industry, not just the data holders, but people that are also innovating in the industry and using the AI systems to be innovative in the industry. It also encourages closed ecosystems. It exacerbates this concept of a black box AI. The AI systems aren't sentient yet, but at some point they're iterating on themselves. And, there is a element of trade secret law that you need to be able to describe the information that is protected with reasonable particularity. And if we get to a point where the AI is iterating on itself to a level where, even the data owners don't even understand how that data is working, maybe there shouldn't be trade secret protections over that data in the first place. And then finally, we're seeing it, public safety and accountability issues emerge in litigation. Bias in hiring or misdiagnosis in health tools, companies invoking trade secret protections to avoid disclosures on some of those issues is going to be an issue that we're going to have to grapple with, both from a legal perspective and just like a policy perspective more generally too. So if we just take a moment to pull together what we've seen so far, while the basic legal doctrines for trade secrets hasn't changed over time. Its application does shift over time with the development of new technologies. And we see that particularly in the AI context. And I think there's probably three major ways we're seeing that kind of evolve or be dynamic. Again, back to this concept of a living doctrine. One is the reasonable measures to maintain secrecy. In a traditional sense, you just lock the server room or you password protect the database or you get the employees to sign NDAs and that's, reasonable enough measures to maintain secrecy. But in the AI world, secrecy is often about how you manage access to that data itself, how you manage access to the model itself, how you protect that information. And today that maybe that's going to have to include prompt obfuscation or restricting model outputs or logging and auditing prompt behaviors. Um, the second prong is what is reasonably ascertainable, or sorry, what is readily ascertainable. Here's where I think where it gets really interesting. If a really skilled user can trick your AI model into revealing its system prompts or revealing its system code, as we saw in the open evidence case, doesn't that mean that your data was readily ascertainable from the outset? Um, and that's an unsettled question that we're going to have to see how courts answer, and that'll kind of shape the future of trade secret protections in this area. And then finally, improper means. We talked about this quite a bit already, but the law has been pretty dynamic and pretty good at adopting the doctrine of improper means as technology evolves and as we start to use different types of AI systems. Um, we're living in an era, where hacking is really just a really skilled AI user being able to get information from the AI system. And that's, somewhere where I think the law needs to catch up with where our technology is, but I'm confident it will. Um, so let's keep moving. We're running a little bit short on time here.
All right, I will cover this quickly. So there are a number of sort of suggested or best practices for trade secret protection that I'm sure you're familiar with that have been suggested to date and are still applicable. For example, on a very rudimentary level, labeling things as confidential. That helps in terms of demonstrating that you are maintaining things as you see value and you're maintaining them sort of secrets to the company. But a lot of practices either need to be tweaked or supplemented. And so, on the left side, we see for sort of companies that are creating AI tools, there's certain aspects that can be considered to be certain protections that can be put into place that may assist in ensuring and shoring up that trade secret protection. Everything from careful selection of training data, right? So at least it's intentional whether or not trade secrets are being used in the training data. And if they are intentionally being used, right, that's a conscientious choice by the company as a whole, as opposed to, for example, an individual employee. Also, there's the aspect of documenting human input. So we talked about sort of the various components of, for example, creating an AI tool, right? Documenting the human inputs piece of that not only helps to then define what the trade secret is, right? Because you have to talk about, you're thinking through what the human input is versus what the AI input is. But then it also might assist further down the road if the company were to decide that it wanted to have sort of a strategic shift and instead of protecting it or maintaining it, protecting it as a trade secret, obtain another form of protection like IP protection, right? Like patent protection or copyright protection. And there's that then focus on the human involvement piece. And then there's also the tracking of the economic value associated with the trade secrets. Oftentimes, that's a very difficult thing to do in trade secret misappropriation cases. How do you define and identify the value of the misappropriated trade secrets? But if you have licensing deals or, for example, valuations of the company that are looking at differentiations between your company and competitors, right? And that the differentiation is information that is proprietary and you find to be information that sets you apart and has that value and you're maintaining it as secret, right? That's trade secrets. That would fall under the umbrella of trade secrets. And then the sort of the valuation then helps to sort of draw a closer line as to what specifically would be the value of the trade secret information. On the right side, you have the use of AI tools. We've talked about this, so I won't go through each one, but things like if it's an option, using enterprise models, right? Because then in the situation of the discoverability of user chat logs, enterprise models were cut off from that and held separate and apart from it. And companies have more control over how those models are used and where that information goes. And then also things in terms of, the use of those tools with private accounts versus company related accounts, and then also monitoring and potentially restricting employee access to publicly available tools to be able to sort of safeguard and prevent the unintentional disclosure of trade secrets. And at the intersection, then we're looking at the creation and use. And this sort of looks at sort of two sides of it, both the technical safeguards in place. We're looking at sort of internally faced safeguards and internally being things like access and how much information can be downloaded, what sort of external drives can be used, people's ability to access their personal email. And then sort of externally, you're looking at sort of cybersecurity, password protection, firewalls, protecting against potentially bad actors. And then legal safeguards, NDAs, sort of licenses, that sort of thing. And then, employment related best practices that might already be in place, but need to be tweaked to account for the nature of AI and sort of the AI innovation or the uses, being seen day to day. And lastly, audits. This is sort of auditing, not only there's this concept of trade secret audits, which I don't know if we'll get a chance to cover, but sort of on the final slide, it walks through how you can the sort of overarching steps that you can go through in order to conduct a trade secret audit, which is just the process of identifying what is information that you'd like to protect as trade secret, and then ensuring you have the adequate protocols in place to protect those. And then also an audit for cybersecurity, so in order to shore up that internal protection and that external protection. All right. Sorry, I spoke a bit fast.
Yeah, and we'll move quickly through the last few slides here. But I think one of the most fascinating things about AI systems is how versatile they are, and it can be a really powerful defensive tool in your trade secret strategy as well. And so all the things that Rebecca just talked about, there are AI systems already out there that can help you do this, right? I mean, AI can analyze patterns of employee behavior, irregular access to sensitive files, or unusual login times. They can identify subtle or high frequency anomalies in network activity to figure out if somebody is scraping confidential information. It can automatically limit access to certain proprietary information, monitor suspicious behavior by third parties, vendors. And so I think it's just to move quickly through here, but it's important to remember that there are so many components of AI systems as we integrate it into our business that it can be a very powerful business defense tool for your trade secret strategies as well.
And then actually on that, I think that sort of a more recent issue is the over-reliance maybe on AI tools to help guard trade secrets. I think we saw most recently with the director of national intelligence was at a AWS conference and talked about how they used AI to discern whether what files that had not been released as it relates to JFK's assassination were confidential and what could be produced and should be produced, and then was able and talked about the efficiency of the use of the tool and then the ability to sort of release into the public tens of thousands of documents, but then subsequently realized that those documents that were determined not to be confidential and produced unredacted actually had, for example, a lot of personal identifiable information like social security numbers of living former congressional staffers and that sort of thing. So these tools can be great in terms of helping to sort of identify and protect your trade secrets, but obviously with a grain of salt, that entire reliance on it might not be in the best interest.
Yeah, and I think the takeaway would be that it can be a tool in your toolkit, but it's obviously not a replacement for your more traditional trade secret defensive strategies. Let's skip this slide and go to kind of our final takeaways here. And this is, I think, wrapping up a little bit of what Rebecca was also talking about. I mean, I think that the point is that, implementing a trade secret strategy for this AI world is not a one-off task. It's got to be an ongoing program that you're consistently revisiting and requires some ongoing coordination across departments. We're kind of at time right now. We will make these slides available to everybody that's here today. Frankly, I love talking about this stuff, and so I would be happy to talk about this all day if we had the time. So, definitely feel free to email either of us or give us a call. We're happy to talk more about this. It's a fascinating area of the law that I think super dynamic, and I think we're going to continue to see it evolve over the next couple of years. Um, yeah, so
We will see. We know for sure it's going to evolve in real time. And I think even Ahmed and I, in preparing this presentation over the course of the past couple of weeks and sort of checking in to see recent developments, where each week there was a new development that that was important to cover. And I think that's why sort of coming down to this or implementation of a strategic plan is both sort of shoring up what you've been doing to date to make sure those protections are in place, and then creating a plan to be able to sort of adapt with material developments in this space going forward.
thank you everybody for joining us. Like I said, we will make the presentation available so you can grab the slides. We're always happy to talk about these issues. Again, the secret CLE code word is trade 2025. And I think one of my colleagues dropped the link for the CLE form into the chat so you can enter information to get your CLE credit. Again, thank you so much for joining us, and we look forward to talking more about this interesting topic with y'all.
Thanks all. Bye.